Jesus Christ. You're so funny.
Oh, hi. Hello, Control.
Hi.
You guys are well? Beautiful. Just someone to test. Oh, you guys are? Applicants, yes. Applicants, yes. Mmoja tu asimame hapo kidogo.
Thank you. Kwani unijulia wapi? Hafai kunijua.
Yes, we have to stream.
Tunaelewa, you understand?
Are you for your team?
Hello. Yes. No, nilikuwa sema you can come. You can also talk to your what is it called? Your councils, and then we can begin in the next 10 ama 20 tafadhali. Yes, sawa sawa.
Judges.
Wewe na
What's the physical copy of a fact sheet? They come from me. And I can printed copy. Tony, what is this 3,300 words?
300 words.
The abstract.
Abstract.
It's that we come post.
What are they?
Ethical notions of human rights accountability.
Yeah? What is that?
You're the one who sent it.
Where?
I don't know where, I just know you're the one who sent it.
Oh, these are my color papers. Mimi nilikuwa
for
naziforward tu.
abstract.
Na honestly mimi nilikuwa naziforward.
You're funny.
Group yenu ni 22J.
23.
Mimi hizi groups honestly sijuangi zinakuanga
Couple books zote.
sijui ya like mimi najua tu niko language.
Literally is 300 words.
Yes, cancel.
This year,
Oh yes. Now that one now will depend on them, but okay. So 25 minutes is okay. 13?
25.
Yeah.
Okay.
It's on you guys to decide how you're going to develop. Yeah, so like maybe 4, 4, 4, 4, and then you also have to leave input for rebuttals or side rebuttals.
Or 6, 6. Essentially, 300 words.
300 words, Simba, siko tu sawa. Is it okay? Felicity, inaonekana she's not coming. Can this be in the area? I will not force Felicity to come. Can we speak on the mic?
This one.
Speak on the mic. It's on.
Yes, cancel.
Unless the volume, you have to be more audible than that.
Hey, yawa. Guys. Go better.
You'll have to be audible because Najua, we've intercepted feed from this. We've intercepted feed from this. So in order directly to. Yes.
Okay. Thank you.
So basically, people in the live stream will hear the microphone, they will not hear us. Do you get understand? Oh, let me come to your robes, by the way. Wow, let me come to your robes.
Nasoma sana. Very serious note, sijasoma hiyo. Niko tu hapa for the vibes. Do you know how busy I have been lately? Ni how many pages?
Refu sana.
You're not helping.
I think 20 something.
Hey.
Si refu. Ukikompea na ile ya sijui Christopher si ni fupi sana.
Mbona hizi kulifanya? Kwani
Hivi soma hivi. Ndio hiyo. Niache utasoma isalisho.
Sasa unajua mimi si wewe. Wewe umesoma, mimi sijui kusoma. Si mo.
Nilikuwa nakusema. Amekitiko hivi, malaika leo ngolo.
Si ndo?
Si tuko live sasa. Hapana. Acha niambie tukishaka huko jamaa. Present and voting.
Mbona unasema present and voting?
Si hivi nilikuwa tunafanya kwa nini?
UN. Kwa
Ina kwa rais sasa.
mbona hujajui timu?
Tunafanya ICT.
Mungu ICT, bure kabisa.
Wa.
Mimi lazima nipe kila mtu ICT, wakuje ICT.
Si naona ikiwa uzungu sijui mbona na nguvu.
The moment
Naona
you start
ushatabia
to
Vincent.
Ushatabia
Vincent.
Vincent is having the time of his life.
Yote. Na mwenye hapa na nasikia ametake 6 hours anasikia kukufa.
Ananiambia ilikuwa rahisi sana ndani.
Tunakudana ni.
For now, you know.
Jana alikuwa na
General.
Because imagine a president began and you
Kuambia your competition, so you find out on Friday.
Azali yako na. 6,000 unaenda kutaibaje?
Let me tell you that on Friday.
Natafuta article yenye inaongelea maana. Na confess na ndio ndichini. Because I don't even know the citation.
Alafu sina skill ni nini Muslim hiyo article tunataka. Sasa yeye sijui tulisubmit memorials 2 minutes late.
Ni sawa. Si mtakula tu penalty. Ama ambaye penalty.
Mimi niliona tunachuja unakuwa disqualified.
Kama alisubmit email. Kusema why you are late and 2 minutes si mingi sana. Ama ni aje tu.
2 minutes here?
Alisubmit memorial 2 minutes late. Yeah, it's easy.
But nah, sisi tulisubmit one weekend later. Lakini hiyo ni juu ya Imelda. Imelda was so nice to us. I love Imelda. Yeah, there's a lot of drama right now. But yeah, Imelda was so nice. So mnaweza ongea hata na Imelda. What's the news about?
Imelda that tough judge like her.
Imelda is a judge again.
She was a judge at Kuila ICJ.
Oh, mimi nilimwacha tu akiwa registrar.
Yeye ndiye alitutemesha Kenya kesi.
Wow. Well, she's a good. She was in All Africa. She was in All Africa the last years.
I saw that.
Amazing lady, amazing.
Okay, no. Antonina didn't say
You're coming to a court.
Yeah. You didn't say that. She called me and I was dressed. Was you to take what I'm wearing?
Wow. No, I'm wondering where are these groups? Which are the groups of myself? Yes, so for whoever shall be presenting, this is just aesthetics. Aesthetics. Please wear your wardrobe. Yes, we don't have parties. I don't know about me, it's just an internal mood. You know, we're just trying to kind of improve the mood culture. So we had don't think it's a big thing. Even if they've been here, you know, I have judged the area, you know, 2 years down the line, you don't Nelson Mandela inaanza lini? Deadline? 23rd. I'm waiting on your co-counsels. Waniambia wako shule, they are preparing.
Wametend.
Oh, pole. Nilikuwa ni setup. For now,
I'm opening a petition.
No.
You realize that you're infringing my right to privacy. Like, very nice.
Oh, welcome, Council. Yes, before Mketi, please share the live that is on your phones. Share it to your friends. Because as we stand, we are live. So share it to your friends. You can share it. As we stand, we are live. You guys are here. Oh, share the live. Yeah, share the live. And apologies. itakuwa mimi. Cancel your them.
Shut up,
That's how it works. Just want to make it as fun as possible.
You are defaming.
Relax. That's what's up. Then the judges can give me ground rules.
Please do so that.
I was sure give me a break.
Send the large. Oh, this is okay. You don't have. I'm looking for one. So we do not have one. So next up.
What?
Next up. You will understand.
You want to understand me?
Next down. Where? Next down. Next down. Well, we tell you this.
No, not 6 months.
Huh? Just write down this one now. It is. And then because I want to break down the grades with the
Wait, I'm not so how
where? Leave my medals.
that is not your mood.
It is technical.
It's not called the animal. But it is under we have to our names. Nobody was they had that name.
In the meantime, they will squash it.
But we want to score that's the issue.
That one here. Kwanza ya July tutakuwa na discrepancy. When we participated before.
Oh yeah, we already talked to the coordinator and like I say, as long as both members of the team we're not substituting. We've had it in different participation. You don't do that for people. I can't do a one. If you love
Alafu bado tutakuwa na nchi hii.
yeah, we still
That woman doesn't train people.
oh she does.
She doesn't. She really train with what?
She got for us training.
She got you a training, but she does not train. So the entire time here provides.
Yeah, but when she went for shopping.
Yes. So why not train?
Yes, no,
Yes. So far in the live stream, I don't think we have any other problem. So she really doesn't train. But we also have to submit a proposal also because we also have to get staff. I don't think Julie is in a position to get a spot.
Yeah.
That's to Mohammed Mapema.
She's aware. She's people who have the visa. She's aware. Working with her, especially if you ask her, she'll do everything. She's the one who goes to the that she's putting up on visa
Yeah, anataka tu kutembea.
yeah, anataka kutembea. But she did that.
She doesn't.
She
Does
does.
not.
If she looks for the sponsor, then she did that. She looks for trainer, she did that.
Atusaidie hata ndani ya mtani
She
atusaidie.
doesn't have those types of skills.
Exactly.
But she does have connections. And we won't make things with her. Who do you suggest?
Well, napenda vile Rogers anasaidia tunafanyia naombi.
Or with the
Space Moot, yeah.
so you want her.
Yeah, like I want concrete help. See ati nikaa tunaenda hapo kutoka. Yeah. So I want help tufike final. Kwani mimi na graduate nishike kutoka Paris.
Through my fault you're graduating.
For now, let's start with ground rules. Just this general ground. Time allocation, 1 year, yeah, the bench is here. Mimi am here for mimi nasimama pale. Mimi am the camera. Yeah, share the line obviously, and now you are that. This is actually better. That is why I got one. We can use this situation, so it's not horrible. I didn't want to comment about it. Man, what society is about. But what I want most to comment, ways to improve. Basically, I just want to comment. Come last time at performance, we got to like a rating system. People need to improve. And I want this so yeah, so that once we are done, they know how they feel, they know how they feel. Yes, let me leave you the bench, please. That's all. 5. But 25 minutes per team. 25 because no, because them they are 4. They are 4. We can't give them 20. This they will be okay with 20, but then they wouldn't. So 25. Sari battles. Oh, should we have Sari battles?
Yes.
So you guys are doing Sari battles. Like you're rebutting what they said. Just imagine the battles and just doing the opposite. Good. Not the opposite, but Sari battles. You guys are doing the battles. So like basically, what they say, you rebut. If they said something, they will explain. What? So yes, I do not know if you guys will be comfortable with this. The door it's up to you. Please do share the live to as many people as you can. And now I will leave it to the judges to explain before we begin.
Good morning. My name is Aruna Chamtai, and for this session, I'll be the presiding judge. I'll allow my co-judges to introduce themselves, starting from my left.
Greetings. My name is Oware Felicity Dea. I will be co-judging alongside Zarina Chamtai.
Good morning. My name is Nerea Kinyi. I'll be the co-judge for today. Have a nice time.
Okay, so for for ground rules, let's minimize movements, especially for those in the crowd, so that we don't disrupt the session. Observe court demeanor. Yes. Okay, I think that can start whenever you're ready. The applicants. And before we begin, can you introduce yourselves?
themselves. May it please the court. I'd like to have the lead counsel for the applicant. My name is Brian Onyango, and I'm going to allow my co-counsel to introduce themselves. They're mentioning their name. On your left, I have
Melanie Nyaga. Come again. Melanie Nyaga.
For the record, Wamani Wadek.
Pardon?
Wamani Wadek. Wamani Wadek.
I'm sharing this. Sharing this video. Sharing.
everything is okay. So with regards to time, we see that you have been allocated 25 minutes. We beg to have the first issue have 5 minutes. The second issue 7 minutes. The third issue 5 minutes, and the fourth issue for 5 minutes. And lastly, the rebuttals 3 minutes. With that, I'd like to introduce the first counsel to present on the first issue.
Honorable Justices, may it please the court. My name is Nyaga Melanie Olucho, and I'll be presenting on the first issue, which is whether this court has the jurisdiction to hear and entertain this appeal, as well as whether the appellants have the jurisdiction, have the local standing to bring this issue to this court. So, first, whether this court indeed possesses the jurisdiction, appellate jurisdiction, to entertain this appeal, and they draw authority by Article 163(4)(a) and (b) of the Constitution, which provides that appeals shall lie from the Court of Appeal to the Supreme Court on rights in any case involving the interpretation or application of the Constitution, as well as any other matter of general importance. And this court has ruled in the case of Peter Ngoge versus Francis Olikaparo that it has the right to hear only cardinal issues of law or of jurisprudential moments. Further, it has provided in the case of Nixon Ngugi versus the Commissioner of Lands that to invoke its jurisdiction on matters of interpretation and application of the Constitution, one needs to highlight with precision the articles which are to be interpreted and applied.
The case. Before which court and which year?
Okay. The first case is Peter Ngoge versus Francis Olikaparo and 5 others, which was petition number 2 of 2012 before the Supreme Court of Kenya. And this case is Nixon Ngugi versus the Commissioner of Lands, which is petition number 9 of 2019 before the Supreme Court of Kenya.
Well cited, counsel. Could you perhaps give us brief facts of the said cases and draw similarity from that case with our current case?
In the case of Nixon Ngugi versus the Commissioner of Lands, this court provided that to invoke its jurisdiction on matters of the interpretation and application of the Constitution, one needs to highlight with precision the articles which are to be interpreted and applied by the court. And in assessing our matter, they are Article 31, which provides for the right to privacy, Article 27, which provides for the right from the freedom of which provides for the freedom from discrimination, Article 10, which provides for the national values and principles of governance, as well as Article 18, which deals with public access and participation. Also, Section 3 of the Supreme Court Act of number 7 of 2011 provides that public participation is a core mandate of this court, and as such, it has the right to hear and entertain cases on the same. Also, the appellants have the right to bring this case before this court because in assessing their legal capacity, the Digital Rights Watch Network actively advocates for the digital rights, data protection, and an enabling environment in the ICT sector. This case handles the violation of the right to privacy, which came about due to the enactment of NIIMS, and as such, we possess a legitimate interest in the matter. Thank you.
What does NIIMS stand for?
It stands for National Integrated Identity Management System, commonly known as Huduma Number. And as such, I'd like to ask this court to entertain this appeal as it possesses the jurisdiction. Thank you.
Counsel, you are handling the first issue, right?
Yes.
Kindly address on locus standi.
The appellant indeed possesses the legal capacity to bring the matter before this court because it handles the right to privacy as well as public participation. The appellants aver that the enactment of NIIMS did not actively involve the public to an extent that is acceptable under the law, and as such, the public participation mandate has been violated. This court, in the case of Communications Commission of Kenya and 5 others versus Real Media Services Limited and 5 others of 2014, stated that in cases of establishment, licensing, promoting and protection of media freedom, public participation ensures that private deals do not happen, and as such, the public has the right to be actively involved in such policies as it directly affects them. And the appellants, in this case, first we have the Digital Rights Watch Network, and also have the Kenya Human Rights Advocates. They have the legal capacity and a legal interest in this matter because they are defending the rights of the Kenyan people, which are actively provided for under the Constitution and have been violated through the enactment of NIIMS.
Well cited, Counsel.
Are you aware of
The
article within the Constitution
that provides for matter
that states the parties that can appear before court?
You've just stated on the issue on public participation that the level of public participation by the respondents was not an acceptable level. What is an acceptable level of public participation?
Thank you for the question. The unacceptable level of public participation was also provided for under the Supreme Court Act, and the court emphasized that the matter that for public participation to be to an acceptable level, it has to include clarity and the subject matter for the public to understand. The structures and process of participation have to be clear and simple. Also, the process must be inclusive and there must be effective representation from the members of the public for it to amount to clear public participation.
Counsel, what remedies are you seeking before this court with regards to that issue as you conclude?
As such, I ask this court to entertain this appeal as it possesses jurisdiction.
Okay, for the record, I'm going to handle issue 2 on whether public participation. I'm going to handle issue 2 on whether enactment of Section 9A in the Registration of Person Act violated the core principle of the Constitution of Public Participation, and whether the procedure of the enactment was flawed. May it please the court, I'll start. My lord and my ladies, this is a moment where democracy has been ignored. This is a moment where public participation has been sidelined, and we have hope and believe that this court has the power to restore it. We submit that the enactment of Section 9A violates the core principle of public participation, and it never met the threshold of Article 10 and 118 of the Constitution of Kenya. My ladies, public participation is the bedrock of democracy. We can see that in Article 1 of the Constitution. We can see that in Article 25 of ICCPR and Article 21 of UDHR.
Kindly give the full citation.
Citation of the international laws that you're citing, like the ICCPR.
Okay. Article 25 of the ICCPR, which give the sovereign power to the people, the authority to, which allows the people to have the sovereign power to vote and to participate in every act of governance of the people, in every legislative act.
What my co-counsel is trying to ask is, what is ICCPR?
Okay, thank you. ICCPR is International Covenant on Civil and Political Rights. UDHR is Universal Declaration of Human Rights.
Thank you.
Okay, proceed.
And counsel, now that you are addressing public participation, and I want to believe it's your first legal argument, right?
Yes.
Can you address us on the principles of public participation?
Okay, I'm going. Okay. So, the principle of public participation was seen in the Supreme Court case of 2019 in British Tobacco by the Ministry of Health, where the Supreme Court stated out the principle and said that public participation must be real and not illusionary. It must have both qualitative and quantitative components. Public participation, there should be a reasonable notice and there should be a sufficient time. It's a matter of natural governance. And in sufficient time, the court said that it's going to be weighed based on the courts, based on each case's facts. So it's a case fact. It's going to be assessed based on the case facts. So we contend that public participation in our matter was inadequate. And I'm not going to reiterate on what I initially said, putting us on the same case. So we also aver that the notices in this matter were insufficient. We have seen that the available were insufficient, and the ones that are available were only published in English and Kiswahili. I like to contend and I like to put reliance, and I like this court to take the same position that was taken in the case of Mogale, by Speaker of National Assembly in the Constitutional Court of South Africa, paragraph 16. Okay.
Before you cite the case,
okay,
you've mentioned some facts that the publications were only done in 2 languages. Can you guide us to which paragraph of the fact sheet you are referring to?
19, paragraph 19. Yes, paragraph 19. So it was only done in 2 languages. They failed to consider that Kenya as a country has linguistic diversity, and we have different literacy levels. So in that case, the case it borrowed the same facts, and the notices were insufficient. Another thing, the notices were only published in English languages. So the court stated that since the matter was of public importance and it affected the Khoisan people, the languages, the publication should have in it the Khoisan language and not English only. So it's our submission that since Kenya is a country with linguistic diversity and different literacy levels, we don't believe that every person in Kenya truly understands English and Kiswahili. Okay.
And so, why is it found in the fact sheet that
your citizens will not understand the English language, or that the concerned community or the community that is affected in this case are not able to understand English and so on.
It was not clearly stated that they didn't understand English and Kiswahili, but you look at paragraph 19 of the same, it speaks of, it's almost similar of the Somali and Nubian people or the marginalized people, and they couldn't understand the English and Kiswahili not clearly.
The fact sheet states that they could not understand.
It doesn't state that necessarily.
Then if it does not state, then you are misleading this court, counsel.
Okay, stand right there. Okay, we further contend that there was no meaningful community consultation. So we put our reliance in Poverty Alleviation Network versus the President of South Africa, where the court emphasized that meaningful engagement with communities allows the community members to express their concerns. In here, we found that the community was never engaged meaningfully. We further aver that in the recent case of BBI case, in the AG and two others, was Ndi and 79 others, Justice Smoky Wanjala, as seen then was stated that inadequacy of public participation renders the whole process unconstitutional. You look at the opinion of Justice Smoky Wanjala.
Counsel, I have a question.
Okay.
Are you solely relying on paragraph 19 to make your submissions on public participation? Can you give us to any other fact that can prove to us that public participation that was conducted by the respondent was not sufficient, as you claim?
Unfortunately.
And one more thing, as you address us on that, what amounts to sufficient public participation in a bill? Because what you are alluding on is the public participation was not sufficient. So can you guide us on what sufficient public participation amounts?
Okay. So basically, I'm relying on paragraph 19 because it's captured the whole component of public participation in that case. And what really amounts to public participation, I like to borrow the same words of Smoky Wanjala, as he said there, lack of a prescribed framework for what really amounts to public participation isn't an excuse for not conducting it. So I think as a quota, we'll try to, I'll try to pursue that public participation, as I've said initially in the case of British America, it should be, in fact, it should be real, not illusionary, and it should have both qualitative and quantitative components, reasonable notice, etc. So the jurisprudence of Kenya has not said that what really amounts to public participation, what is sufficient. It doesn't answer that question of what really is sufficient public participation. So
a follow-up question. You submitted that when assessing whether public participation was effective,
two tests have to be satisfied, that is the qualitative and the quantitative test. In this case, could you kindly guide us what measure you've used to speak to the quantitative aspect? You've spoken to the quality in terms of the language barrier not being addressed. So kindly address us on quantitative. Did it meet the quantitative test?
No, it never met the quantitative test. I don't have the paragraphs to rely on there. Okay. I'd like to submit on the procedural flaws in the legislative process, and then I'll conclude. We submit that in the introduction of Section 9A through an omnibus bill was a means to evade scrutiny. So we rely on the Supreme Court of West Virginia case in Kincaid, Bolen versus Mangum, where the court stated
on what grounds are you relying on that case?
on that case, there was the introduction of a bill which in it had many other bills in it, like the bill that was introduced here, the NIIMS. So on that case, the court stated that introduction of omnibus bill bypass public scrutiny, and its deviation. This deviation does not only violate procedural safeguards; it also diminishes legislative processes. So we have heard that Section 9A introduction during the parliamentary recess limited the parliamentary debate, and we like to put our reliance on Article 10 and 118 of our Constitution, which mandates open governance. So it never made a threshold of open governance.
Council,
Okay.
whatever you're alluding on is that the enactment, is it the enactment or the introduction of Section 9A, right, was not done in the right procedure. Can you guide us to the facts on what the government did or the respondent did that did not follow the due procedure that you're supposed to follow, and what they were supposed to do, so that you can be able to understand where you're coming from?
Okay. The first thing, the enactment was done through an omnibus bill. So that's the
Which paragraph, Council?
paragraph 4. Was done through an omnibus bill. So introduction of such using an omnibus bill bypasses public scrutiny, and this deviation not only violates procedural safeguards, it also diminishes legislative process. Another thing, the introduction was done during parliamentary recess. So you will find in paragraph 12, it was done during parliamentary recess. So this limits parliamentary debate, and it violates the core principle of Article 10 and 118 of open governance. Okay. I like to make a brief comparison between this system and the Indian system. Indian system, the Aadhaar system of India, is almost similar to this Huduma number system. And it is one of the biggest systems because it has over 1 billion enrollees in it. But the issue with the Aadhaar system is, what made it a success is there was robust legal frameworks in it. In our system here, we are introducing it and we don't have any frameworks in it. We don't have any legal frameworks in it. So it is to our submission that because we lack robust legal frameworks, the rush of the enactment of it is already flawed. So I like to conclude by saying public participation is not a mere formality. It is a constitutional safeguard.
Council,
Okay.
I'm quite interested in knowing your view on paragraph 5. Under paragraph 5,
Okay.
the respondent alludes that public engagement was conducted through parliamentary committee hearings, public advertisements, and stakeholder consultations. Doesn't this, in your view, amount to sufficient public participation?
It doesn't amount, since on the same, we see in paragraph 19, saying that the community was not meaningfully engaged. In the same paragraph 19, there were inadequate notices, and in the same, it was only published in English and Swahili. And about the parliamentary committees, we see on paragraph 12, the parliament was already on recess. And we have seen that it was introduced using an omnibus bill. So, on my view, it doesn't amount to sufficient public participation.
Council, this is a court of law, not a court of opinion. So kindly guide us on what law you're relying on.
Okay. So, based on those paragraphs I've listed, and based on the case that I've already stated before, I think they are in support of my opinion. Okay, I'll continue. Public participation is not a mere formality.
Council,
Okay,
your time is greatly spent. Kindly conclude.
1 minute. I'll be done.
Yes, you're granted.
Public participation is not a mere formality. It is a constitutional safeguard against arbitral abuse of power. And I'd like to reiterate what my co-counsel said, Section 3 of the Supreme Court Act. And I'd like to quote the words of Nelson Mandela in his autobiography. He said, everyone who wanted to speak did so, and it was a democracy in its purest form, and everyone was heard. So I think everyone needs to be heard in this matter, and it is my prayer that this court shall find the enactment of Section 9A unconstitutional and shall declare it null and void. Okay.
Honorable Justices, my name is Charlene Disio. I'm representing the appellant, and if it pleases the court, may I proceed? Honorable Justices, my name is Charlene Disio, representing the appellant, and if it pleases the court, may I proceed? I'll be addressing the issue on whether the National Integrated Identity Management System Integrated Identity Management System violates the constitutional right to privacy under Article 31 of the Constitution of Kenya 2010. Article 31 of the Constitution of Kenya 2010 provides that every person has the right to privacy, which includes the right not to have information relating to the family or private affairs unnecessarily required or revealed. The National Integrated Identity Management System required confidential information, which included the biometric.
Counsel, I have a question. Is the right to privacy absolute?
Yeah, I believe so, because the law.
Counsel, I believe.
Your Honor, the right to privacy is absolute, because the law hasn't. I will answer that because I have a part on the Data Protection Act that deals with the question.
Okay.
Yeah. Okay. The National Integrated Identity Management System was established by the Kenya's Amendment Act number 18 of 2018, which introduced the Section 9A of the Registration of Persons Act, CAP 107. So this system requires confidential information, as I said earlier, including the GPS and the biometric system. We believe that this infringes the right to privacy of the individual. The system was introduced when there was no law that ensured the protection of the data that was provided. Because the Data Protection Act of 2019 was enacted months after the NIIMS was already introduced. So because there are no laws that ensure the protection of the data of the data subjects was prone to data insecurity. The purpose of enacting the Data Protection Act of 2019 was meant to mitigate the risk of data insecurity. However, we believe that this act has flaws because it hasn't provided the specific legal frameworks which is going to ensure the protection of the data that was provided by the data subjects. Furthermore, the Huduma number registration form has a disclaimer that provides that by providing your information on the form, you are consenting to your information being provided to any other authorized government agency or agencies. Therefore, this infringes the person's freedom of choice to choose where his data is going to be used.
Counsel,
Yes, Your Honor.
were these citizens forced to take the Huduma number, or they willingly
The Huduma number, because the government stated that the Huduma number is going to be necessary to have access to public services. So therefore, most people are inclined towards having it so that they may be able to access the public services.
Counsel, I have a problem with that line of thought, because for coercion to be there is no ultimatum. What it looks to me is a government that was trying to ensure that its citizens are not barred from seeking government services. So they told them, they accessed information to them and told them, please register so that you're not barred from accessing government services. It was not an ultimatum. They were not forced. They had a choice.
No, yes, you do have a choice, but according to how the Huduma number came about, before you are able to access the public services, you are required to have the Huduma number. So if you don't have it, because this leaves the person with no choice, because at the end of the day, whether you want to have the public services, you still have to have the Huduma number. So this will make people to actually apply for the Huduma number. So at the end of the day, with the disclaimer that has been provided on the Huduma form, you don't have the choice to choose whether your data that has been collected on the Huduma form can be given to any other government agency.
Thank you. Counsel, this guides me to the question that was asked by my learned co-judge, Judge Nerea. Is the right to privacy absolute?
The right to privacy is absolute because we believe that's the most fundamental aspect of being a human being, because you need to have control over who has access to your data.
That is pursuant to what?
The natural rules of justice.
Counsel, the natural laws of justice don't speak to the right to privacy being absolute, and it is not an absolute right. As a matter of fact, it can be limited under Article 24 of the Constitution of Kenya. And when the government has given a reasonable and justifiable cause as to why they are limiting the right to privacy, then they can do so. What was the reason that the government gave to collecting or accessing the data of the citizens?
Because they wanted a centralized system that has the data of every individual in the country.
Is that not a reasonable and justifiable cause?
It is not, because once you have the Huduma number, the fact that on the disclaimer that the government can use the data that has been provided there to any government agency. Now that exposes your data to secondary use.
Council, what government agencies are going to use this data to do what? They're not going to do harmful things. They're going to use the data in order to ensure that the citizens themselves are accorded access to these government services. These are government agencies. They're not giving it to private entities to use it for their own means. Also, since the right to privacy is not absolute, kindly give us a test that analyzes the justifiability of limitation of a right, specifically the right to privacy.
About the right to privacy, because I still think that because the government allows the other government agencies to have your data, we believe that that limits your choice as a person to choose when your data is going to be used by the other government agency, because I believe that you have to be in control of the data that is being given, because the Data Protection Act also allows the
Council, as you address that, I'm quite concerned because under paragraph 1 of the facts, the reason given by the government for collecting this amount of data is due to national security purposes, which Article 24 of the Constitution justifies the limitation of this right on the grounds of national security and public interest, right?
Yes. However, the specified what amounts to national security has not been specified by the law, which leaves it a bit ambiguous, because we've not been told that this amounts to national security or this does not know. So what criteria needs to be used to determine that this amounts to national security?
Well stated. What is the criteria that determines national security? So that you can demonstrate to us that this was not a matter of national security. Which threshold are you using?
The law hasn't provided a legal threshold on that yet. That's why I believe it is ambiguous, because we have not been told this one amounts to national security and this one does not. So this leaves it a bit vague.
Address the threshold for justifiability of the limitation of a right.
The limitation of a right. Wait, pardon? Could you please repeat?
The right to privacy is not absolute, can be limited. Mm-hmm. So how are we, and the threshold that has been given under Article 24 is that it must be reasonable and justifiable. Show us that the accessing of this data, which was an expression of the limitation, and I know that the government is going to say it was an expression, an enjoyment of its right to limit this right. Show us how it was not reasonable or justifiable. Are you aware of any test that analyzes the limitation of a right?
Not per se, but it is not reasonable or justifiable because the kind of information that was required, including the GPS, because how is it that the government, knowing exactly your location, how is it going to contribute to the national security or the public interest?
Your opinions are convincing, but they're not binding before this court. So once you've given us your opinion that they've taken GPS coordinates, which you think is an overreach of their power, you have to show us in the law, common law, jurisprudence, anything that backs you up, apart from yourself.
But Section 51(2) of the Data Protection Act provides that the processing of personal data is exempt from the provisions of the Act if it is necessary for national security or public interest. I don't have a specific that is going to back me up on this.
Councillor, I have a question. In your submission, you stated that the NIIMS the system, the NIIMS system or whatever, lacks provisions that will address security risks, that the system is prone to security risk. Can you guide me when the case facts that it stated the system does not have provisions and the system is prone to security risks?
Which was relying on the Data Protection Act mainly, which was enacted months after the NIIMS was already established, right? And the Data Protection Act in itself has flaws because number one, Section 28(2) allows that personal data may be collected.
Counsel, I just need the paragraph in the case facts.
I don't have. I didn't indicate it.
I know your time is far much spent, but before you conclude, I have a question. Are you privy to the principles of data protection?
Mm-hmm.
Kindly address us on some of the data protection principles that were violated in the present matter.
I'm relying majorly on Article 31C that provides that the right to privacy, everyone has the right to privacy, which includes the right not to have information relating to their family or private affairs unnecessarily required or revealed, because the NIIMS system wanted confidential information, which I believe that the person is a private affair to the person. So this violates Article 31 of the Constitution of Kenya 2010.
Conclude, Counsel.
Therefore, with the foregoing reasons, I urge the court to issue an order to nullify the NIIMS system.
What type of order?
Prohibition. Mandamus to stop the enactment of the.
Okay, cede the floor kindly.
Honorable Justices, and may it please the court. My name is Brian Onyango, and I'm going to present on the fourth issue, that is on whether the implementation of NIIMS disproportionately discriminates against marginalized communities, contrary to Article 27 of the Constitution. My name is Brian Onyango. May I proceed? Thank you. Before I proceed, I would like to say that I'm going to discuss my issue, or I'm going to submit my issue in three different parts. The first part I'm going to explain on what amounts to discrimination. The second part, I'm going to give the factual background of the case. Then the third part, I'm going to give an analysis. That is on the merger between the first two parts. And before I begin, I'd like to recite what Article 27 of the Constitution says. And it states that, it provides that every person is equal before the law. And the article further goes on to prohibit the state from discriminating any person, directly or indirectly, on any specified ground. And one of the grounds is on ethnic and social origin. And so we begin. What amounts to discrimination? If you look at the Constitution, you will not find any definition of discrimination. Therefore, I went on to the Blackstone Dictionary, 9th edition, by West, 2009. And it states that discrimination is the differential treatment without a reasonable distinction between the favored and those not favored. Okay? But that in itself is somewhat shallow, as it does not really explain what amounts to discrimination. Therefore, we proceed. If you look at the Kenyan perspective, there's no Supreme Court decision that fundamentally describes...
Counsel,
yes?
there exist international laws that govern matters on discrimination. Are you privy to any of them?
International laws?
Yeah.
Yes, I'm privy to, yes, European Court of... European... What is it called? Human Rights, European Convention on Human Rights. Yes, I'm privy to Article 14, which prohibits discrimination on certain grounds.
Are you privy to the provisions under the United Nations Convention on the Elimination of All Forms of Racial Discrimination?
I'm not, unfortunately.
You can proceed with what you... Yeah.
Okay, thank you. Okay, so I'm with regards to discrimination and defining what discrimination is, I'm going to start with the South African case of Haxen versus Glenn and others. It is a case in 1977, full citation ZACC 2022. And in this case, the court stated that for differential in treatment to amount to discrimination, it must be unfair. That is the first part. And then the second part, and then the case goes on further to explain what unfair discrimination really amounts to. I hope you understood me from the first part. The first part states that differential in treatment based on specified grounds is what really amounts to discrimination. Okay, then the court goes on to further provide for the steps that are required for discrimination to be established. And for discrimination to be established, okay, I'd like to start again to proceed from where I hope that time would be discounted. Okay, let me start again from the definition from the Black Law Dictionary, which says that discrimination is defined as the differential treatment that is accorded to, that is unreasonable, and there's no difference.
Yes? Just start from the South African case.
You start from the South African
Yeah,
case.
and the test that is given to establish discrimination. Don't go all the way back.
Okay. Also, in the case of Haxen, as I already cited it before, it provided for the test to establish whether discrimination is established or not. So the first step, the court looks at whether the differentiation is based on a specified ground or not. If it is based on a specified ground, then it is discrimination. It is discrimination, if I'm not wrong. If the differentiation in treatment is based on a specified ground, then it amounts to discrimination. Okay, and if you look at our case, we claim that the differential in treatment is according.
Counsel,
Yes?
now that you've mentioned a specified ground,
Yes.
can you just give us an instance, an example, or even a case law that provides for a clear distinction between discrimination and differential treatment, kindly? And then kindly marry it to the present facts.
I do not have a specific case law that provides for the difference between a differentiation and discrimination. However, if you look at the case that I have, it establishes that for discrimination to be established, there must be this differentiation in treatment. Okay, that is one of the prerequisites. Okay, then as I proceed, for the first test, for the differentiation in treatment to amount to discrimination, it must be based on a specified ground. And if you look at the current case, the members of the marginalized communities claim that they are discriminated based on their ethnic and national origin.
Sorry to interrupt you.
Okay.
You've come before this court talking about discrimination. They have been discriminated. Yes. I've not heard you stating somewhere in the case facts where these people are discriminated. Can you kindly guide me where?
Okay. As I was starting, I said that I'm going to let me just establish this. I said that I'm going to deal with the issues in 3 steps. The first step, I'm going to talk about on what amounts to discrimination. Then the second part, I'm going to talk about on the factual. I'm going to provide the factual background. Then the last part, I'm going to provide an analysis of both.
When the judge asks for the facts, you give the facts. Give us the facts, kindly.
Okay, I give you the facts. Pardon the question. On a specific ground, then there is unfair discrimination. And in the present case, we have the marginalized communities claiming that they are discriminated based on their social and ethnic origin. Therefore, and social and ethnic origin is provided for by the Constitution as one of the grounds to discrimination in Article 27. Therefore, this particular case meets that that provision.
Council,
Yes.
in matters discrimination, you have to show us which services they did not receive or which different treatment they. What are those?
Okay, based on the facts, if you look at the facts in paragraph 3 and paragraph 4, what the marginalized communities claim
Council,
that,
you're
yes,
misguiding us.
I'm misguiding.
Paragraph 4 does not provide for anything to do with discrimination. It's all about public participation, Article 10. So if you want to talk about discrimination, kindly address us on paragraph 3.
Okay, if you look at paragraph 3, the last part, the last part says that they contended that marginalized communities such as the Nubian and Somali communities faced systemic barriers to obtaining national if you look at the last part of paragraph 3, it says that the marginalized groups such as the Nubian and Somali communities face systemic barriers to obtaining identity documents necessary for NIIMS registration, exacerbating existing inequalities. So if you look at that part of inequalities, it is where discrimination is being established.
Council, according to the same paragraph,
Yes.
it provides that they only faced systemic barriers. These services were not completely taken away from them. They just had issues obtaining them. So how can this amount to discrimination if they are actually receiving the same services as other citizens of Kenya?
If you look at, let's say, the allocation of documents or the particular part on the systemic barriers, these systemic barriers, if you fundamentally look at them, then you realize that they enact or they put some form of discrimination, in the sense that the systemic barrier that is being talked about is the vetting process. Okay? And I want to get a background on that.
Where does it provide for vetting process? Council, we're talking about paragraph 3. I'm trying to understand your logic. If you're talking about the systemic barriers in terms of vetting, can you guide us on the facts where there was vetting process and they were not included?
Okay, based on the facts, there is no such provision.
And then kindly abandon that argument.
So I'd like to mention that the part that you've asked me to abandon was the core part of my issue. Therefore, I'd like to just proceed to the prayers. Because if you look at the facts provided are shallow. If you look at the facts that you gave us, they provided a shallow provision of whatever issue that you're going to deal with. And if you compare it with other cases, it is where you're going to find the more detailed facts. So since you've asked me to proceed, I might as well just conclude. And my prayers, and for that reason, we respectfully urge this court. Yes?
I had a question.
Yes.
Okay, you've come before this court.
Yes.
You stated the system was discriminatory
Yes.
and all of that.
Yes.
How do you want the state to come up with an inclusive system at the same time and at the same time address national security concerns? Do you want the state to go back to the ages of paper and leave alone these NIIMS stuff because it's discriminatory discriminatory when it comes to the marginalized groups and all those people? Can you kindly address on that?
Okay, with regards to the particular issue that I was dealing with, it does not really concern on the part of the security reasons. And my issue, the issue of discrimination, is majorly seen in the background, whereby members of marginalized communities are required to undergo this vetting process. And this vetting process, since they face hardship
Council, you've not understood me.
Okay.
I have told you, that the NIIMS system, you're coming before the court to say the NIIMS system is discriminatory. Yes. The reason why the NIIMS system came about was for national security concerns. And I'm asking you, you're saying the NIIMS system is discriminatory. What do you want the state to do when it comes to inclusivity regarding the NIIMS system, and at the same time addressing the security concerns, which is the main aim of coming up with this system?
Okay, with regards to the state implementing the NIIMS system and also in relance to the marginalized communities, what I'd like the state to do is I'd like the state to remove the vetting process that is required for marginalized communities. If they remove it, then they will allow members of marginalized communities to easily access the services that is required to enroll. So with regards to the NIIMS system, where the problem is majorly first is the vetting process. So this vetting process is the issue.
Council,
Yes.
this bench has noted that you have repeatedly mentioned the vetting process, and you have conveniently stated that it is not provided for in the facts. Now, since you are relying on it solely as your major point of argument before this bench, then guide us on the law that states that a vetting process has to be conducted on matters to do with data collection and this systemic, and your relation with it to the systemic barriers.
Okay. I would like to refer to at section 8 of the Registration of Person Act. Shall I read it?
Yes, kindly read it.
Pardon? Which year? Let me just get the act. Cap 2007 or Cap 107 of 2000 and 2012 investigation. If you look at that section, it empowers the state. A registration officer may require any person who has given any information in pursuance of this act or rules made thereunder to furnish such documentary or other evidence of truth of that information as it is within the power of that person to furnish. That is the provision that you are requesting for.
Kindly state the prayers that you are seeking and cede the floor.
Okay, and for that reason, we respectfully ask this court to declare the implementation of NIIMS unconstitutional as it violates the right to equality and non-discrimination under Article 27.
Respondents, whenever you are ready.
Greetings, my ladies. Appearing before you is first counsel for the respondents. My name is Mugo Blessing Wanjiko, and I'm here. I'll be addressing the first and second issue. My co-counsel, Whitney Nyarangi, will be addressing the third and fourth issue. We will be using 12 minutes each of the allocated time to adduce our arguments and preserve 1 minute for our rebuttals. If it pleases this honorable court, we seek to proceed. Thank you. Without further delay, my ladies, the Supreme Court has no jurisdiction to hear and determine the appeal and the four grounds of appeal before it. My ladies, jurisdiction is everything, and without it, the court has no power to make one more step. It is in tandem with this celebrated precedent that the respondents contend that this honorable court has no jurisdiction to hear the appeal before it because the appeal does not meet the jurisdictional threshold under Article 163 4A and B of the Constitution of Kenya 2010. We advance the following arguments in support of this claim. The petition of appeal does not raise matters of constitutional interpretation and application. The respondents contend that this court has not been clothed with requisite jurisdiction under Article 163 4A of the Constitution of Kenya 2010, as the petition does not involve the interpretation and application of the Constitution of Kenya 2010, neither did the High Court and the Court of Appeal delve into constitutional issues in the judgment of this matter.
Counsel,
Yes, my lady.
you've submitted that it does not involve matters of constitutional interpretation or application, but we have rights protected under Article 31, that is the right to privacy. Is that not a matter of constitutional application and interpretation?
Thank you, my lady. This issue is about alleged violation of human rights. My lady, kindly rephrase your question.
Thank you. You have it is your submission that the threshold has not been met because it does not involve issues of constitutional interpretation and application. Could you perhaps guide us on what is constitutional interpretation and application, so that, because the petitioners have brought a case on the right to privacy, that is a right protected under Article 31 of the Constitution. So it is a constitutionally provided right. Is that not a matter of constitutional interpretation and application?
Thank you, my lady. It is, my lady. By that, I mean that this is not the first time that issue is being talked about. It has been, there is precedence concerning the issue of Article 31 about human rights. So in this court, in this Supreme Court, it is not the first time that other courts have dealt with this issue before, as I will address in my arguments. Thank you, my lady. We submit that for the appellants to invoke and rely on Article 163(4)(a) of the Constitution of Kenya 2010, it is paramount for them to show that in the proceedings, and in particular, the issues before the High Court and the Court of Appeal, involve the interpretation and applications of relevant constitutional provisions. We take note of this court's caution in Daniel Kimathi.
Counsel, I'm quite interested in knowing some of these relevant provisions of the Constitution that was alluded there.
Thank you, my lady. Come with me to the, move with me to the fact sheets in paragraph 6 and 9. My lord and my ladies, in paragraph 6 of the compromise, the High Court cited that the intrusive, unnecessary nature of the collection of the DNA and GPS of the citizens. The fact sheets, according to the High Court, okay. I beg your pardon, let me rephrase myself. In paragraph 6 of the compromise, the High Court cited the intrusive and unnecessary nature of the collection of DNA and GPS of the citizens. In this matter, the High Court, in this matter, did not
Counsel, kindly take 30 seconds to compose yourself.
Thank you. In paragraph 6 of the compromise, the High Court upheld the overall establishment of NIIMS subject to enactment of a comprehensive regulatory framework compliant with constitutional safeguards. My ladies, it is our submission that the High Court did not delve into constitutional interpretation.
I would like to understand your submission. You are stating that since the High Court held that there were no constitutional matters, therefore the appeal is based on matters not constitutional interpretation and application, right?
Yes, my lady.
Do you have any case law to support that argument?
Yes.
Cite it.
Daniel Kimathi Njihia v. Francis Mwangi Kimani and another case of 2015 in this court.
What did the court hold?
I quote, "This is not just another layer of appeal, and its circumscribed jurisdiction under Article 163(4)(a) does not permit the court to adjudicate factual contestation unless they can fit the narrow prism of constitutional interpretation and application."
Counsel, I'm quite concerned. This matter has reached the Supreme Court, yet it's your submission that at the level of the High Court, this matter was not interpreted as constitutional matters, right? And it's quite concerning because the High Court has the original jurisdiction to listen to matters to do with violation of rights that is under, okay, as per the, Article 165, right, of the High Court, the Constitution of Kenya. The present matter is basically presenting the violation of the right to privacy, and this is very evident in the facts because there is extreme violation of the right to privacy protected under Article 31. That is due to the collection of sensitive data. So how do you upload that this matter has reached this court and does not involve interpretation of the Constitution?
Thank you, my lady. What we as the respondents are trying to submit is that the High Court has already dealt with this issue. It is not a new issue to the Supreme Court. Further, the Court of Appeal upheld the High Court's decision that the only problem, the only problem with NIIMS is that it lacks the correct procedure. Thank you, my lady.
I have a question. What interpretation and application, and what amounts to be a matter of constitutional interpretation and application?
My lady, thank you for your question. In Article 163 of the Constitution of Kenya 2010, appeals shall lie from the Court of Appeal to the Supreme Court as right of any case involving the interpretation or application of the Constitution. My lady, this, yes, is a matter of constitutional interpretation and application, but this matter has already been dealt with in the High Court. And further, the Court of Appeal has upheld the High Court's ruling.
Is it therefore your submission that this appeal is based on procedural technicalities and not the Constitution?
Rephrase your question, kindly, my lady.
You've stated that these are procedural matters. That is what the High Court held, that it is only laid out procedure that was not, that is the only problem that was found with NIIMS, and therefore this appeal is based on procedural technicalities and not constitutional interpretation. That is why it can't be heard before this court. Is that your submission?
Yes, my lady.
Address locus standi, and your time is up.
Thank you, my lady. The appellants lack the requisite locus standi. The respondents contend that the applicants lack standing under Article 22.1 and 2258.1 of the Constitution of Kenya 2010. The doctrine of standing requires a party to show a personal stake in the matter. This was reaffirmed in the case of Mumo Matemu v. Trusted Society of Human Rights Alliance, 5 others in 2013. While the applicants may rely on Katiba Institute and another, the Attorney General and another in 2020, the fact of the case involved direct challenge to the constitutionality of executive actions, whereas in this case, there is no clear evidence that Section 9A has caused harm warranting judicial intervention. Moreover, in Okio Mtata Okoiti, the Communication Authority of Kenya and another in 2018, the court ruled that the petitioner must show that the impugned law directly affected them or the public. The appellant's arguments are speculative and do not meet this threshold.
Counsel, which article of the Constitution gives rise to standing?
Thank you, my lady. Article 22.1 and 258.1 of the Constitution of Kenya.
In accordance with Article 22.1, both C and D, persons and organizations acting in public interest have standing to constitute a court proceeding, claiming that a right of fundamental freedom has been infringed, violated, or threatened. Now, the petitioner in this case has cited that they are acting in public interest of the marginalized community and also the citizens of your country. Is that not a matter of public interest? And are they not thus acting in public interest and have standing?
Thank you, my lady. It is a matter of public interest. In this case, the petitioners are the application of NIIMS has not yet caused harm to the citizens of this country. The petitioners are here to speculate that NIIMS and the application of NIIMS will cause harm to the citizens of this country. May I proceed?
Council, I'm having trouble with understanding your submission, because our role as the judiciary is to ensure that we are also taking preventive measures to prevent the infringement of rights. Is it your submission that unless your government has done its part by creating injury, someone cannot come and get even a court order as a preventive measure of the violation of the right to privacy? We have to wait until you have done wrong for us to come here. Is that your submission?
No, my lady.
What is your submission?
We as the respondents, my lady, are taking measures to ensure that it does not reach to that extent. My co-counsel will be dealing with the provisions that we have taken to protect the data of the citizens of this country.
Council, I believe you still have an issue to deal with. Kindly address us on the second issue.
The second issue, the enactment of Section 9A of the Registration of Persons Act complied with constitutional principles. We advance the following arguments in support of this claim. The legislative process was constitutionally compliant. The respondents submit that the enactment of Section 9A complied with the procedural requirements set out in Article 10 and 118 of the Constitution. The applicant's arguments that the law was introduced through an omnibus bill does not automatically render the process unconstitutional. In British American Tobacco Kenya, the Cabinet Secretary for the Ministry of Health and 5 others in 2019, the court held that public participation does not mean that every individual must be consulted, but the reasonable steps must be taken to ensure inclusivity. My ladies, in paragraph 22 of the fact sheet, the draft bill was published in Kenya Gazette as required by law. Parliamentary committee hearings were held, allowing public engagement. Stakeholders, including civil society, had the opportunity to present their views. The level of public participation was adequate. In furtherance of my argument, in Law Society of Kenya v. Attorney General and another case of 2016, the court held that public participation must be reasonable, not necessarily exhaustive. In this
Council, kindly address us on paragraph 19 of the facts. This was the sole paragraph that the applicants relied on. Kindly address us on it.
Thank you, my dear. The appellants argue that the framework governing NIIMS didn't involve adequate community consultation. My lady, the draft bill was published in the Kenya Gazette as required by law. Parliamentary committee hearings were held, allowing public engagement. Stakeholders, including civil society, had the opportunity to present their views. In Law Society of Kenya, the Attorney General and another case of 2016, the court held that public participation must be reasonable. In our case, we submit, my ladies, that these were reasonable measures. The court held that public participation must be reasonable, not necessarily exhaustive.
Council, the petitioners have given a test for public participation that I will rely on. They said that for public participation to be effective, the quantitative and the qualitative test both should be exhausted. Now, in matters the qualitative test, we are concerned both quantitative and qualitative, we're concerned because the publications were made in English and Swahili, which clearly discriminates a certain section of the affected population who cannot be able to read in both English and Swahili languages. That is also pursuant to paragraph 19 of the fact sheet. Also, your government claims that they faced logistical constraints. You did not even attempt to overcome them so that you can reach the actual affected population, Council. How then is the public participation that you carried out effective?
My lady, we understand that they might have faced language barriers, but English and Kiswahili is the national language for this country, my ladies. The Supreme Court, in the case of Finance Act 2023, lowers the bar for public participation towards the fashioning of the parliament or the executive. We therefore respectfully pray that this honorable court finds that enactment of section 9A was constitutional and valid. I'd like to cede the floor to the bench for further direction.
In accordance to you, what amounts to adequate public participation?
Thank you, my lady. Adequate public participation to us must be reasonable. To an extent.
But what is reasonable? How do we measure reasonability?
Thank you, my ladies. My ladies, in as much as we try to engage the public, we cannot reach everyone. So, the reasonability according. The test for reasonability is the number of people you have reached must be more than those who have not been reached.
Pursuant to what?
I stand guided by this court. I'd like to cede the floor to the bench for further direction.
Honorable members of the bench, my name is Whitney Nyarangi, appearing as second counsel for the respondents, and may it please the court, I would like to proceed. I'll be addressing issue C and D, and I'll start with issue C, where the key issue is whether the collection, storage, and utilization of personal data under NIIMS violates Article 31 of the Constitution, which guarantees the right to privacy. I'll further discuss this in two lines of argument, and I will submit as follows. The respondents assert that the right to privacy is not absolute and can be limited for a legitimate purpose. My lords and ladies, the respondents assert that the right to privacy is not absolute and can be limited for a legitimate purpose. We can see this, and I would like to lead the court in the case of Coalition for Reform and Democracy Code and another versus the Republic of Kenya of 2018, where the Supreme Court held that constitutional rights may be restricted when there is a compelling public interest, such as national security and effective governance. My ladies, in this case and in the fact sheet, I'd like to lead this court and say that NIIMS implementation is for effective governance and is for legitimate public interest, and that proceeds to. Let me rephrase. My ladies, NIIMS is for public interest, legitimate public interest. My ladies, NIIMS functions, or the implementation of NIIMS is to enhance government service delivery, eliminate corruption, and eliminate duplication of identification, removing corruption, and not enabling ghost beneficiaries of the state program. Another thing will be facilitating service delivery and enhancing national security. This in itself is a legitimate public interest for the nation.
Counsel,
Yes,
could you
ma'am.
kindly guide us to the paragraphs that you are relying on to get those reasons?
Very much obliged, my lady. I would like to move with me to paragraph. Just a minute. My lady, move with me to paragraph 1 of the fact sheet, where it states that, and I quote, "The system sought to consolidate all personal information of Kenyan citizens, and NIIMS was marketed as a groundbreaking innovation in governance and data management, promising to streamline access to social and economic services." My ladies, I'd like to further lead you internationally to the Article 6, subsection 3 of the African Union Convention of Cybersecurity and Personal Data Protection, where it recognizes that data collection by the government is lawful and can be used for the interest of the public. And as I have stated before, NIIMS is legitimate and can be used according to Article 24 of the Constitution, where it states that a right or a fundamental freedom can be used and cannot be limited except by law when only it is reasonable and justifiable. In this sense, my lady, the collection of data of the citizens for the implementation. Yes, my lady.
Can you, let me draw attention to paragraph 25 of the case facts.
Paragraph?
25 of the case facts.
Yes, my lady.
You can go to the, begin reading from the third line.
Where it states that they also cited.
Yeah.
Okay. They also cited examples from jurisdictions like India Others program, claiming that systems have yielded substantial socio-economic benefits when implemented responsibly.
Okay, thank you so much for that. Council, are you aware of the Aadhaar system?
Yes.
And the respondents are submitting that they're using the Aadhaar system as an example of how effective the NIIMS system is. Are you aware of the precautions that came with, or the effects that came with the Aadhaar system?
The effects that came with the Aadhaar system. My lords and ladies, the system has been proved to work before, and I'd like to proceed and lead you to paragraph. I'd like to lead you to paragraph 15 of the fact sheet, where it states that in response, the respondents maintain that NIIMS is a transformative initiative and at improving service delivery, national security, and economic planning. And moving forward, it states that it cites successful implementations in countries such as Estonia and in India. My lady, India has...
Cancel.
Yes?
You've not answered my question. I've asked you, are you aware of the effects that came with the Aadhaar system?
I stand guided.
It's cons. Okay, let me guide you on that. The Aadhaar system came with a lot of effects, such as the duplication, where people went there and they found that there's a duplicate of their identification and all. Some people are being denied access. And in addition to that, there were security risks that occurred with the Aadhaar system.
Yes.
How do you want us, as members of the bench, to agree with this NIIMS system and all its implications if infrastructurally and technically it's the same as the Aadhaar system, or we're not seeing anywhere in the case facts where they have addressed the issues that came with the Aadhaar system? Can you kindly guide us on that?
Much obliged, my lady. NIIMS, popularly known as Huduma Number, is an evolving system, and the government or the state is implementing safeguards in reply to the public concerns. My lords, I'd like to lead you to the fact sheet, paragraph 23, where it states that the respondents also contend that data collected under NIIMS will be stored in a highly secure central database with multiple layers of encryption and access controls. This is to ensure...
Cancel. Let me just catch you, kidogo. You've relied on paragraph 23, and I really thank you for that. When you look at paragraph 23, the same strategy, the same kind of database was used in the Aadhaar system. And let me guide you in the case of in the Aadhaar system and how it worked. In the Aadhaar system, they used the encryption to prevent security risks. But do you understand that when messages or information is encrypted, it will need to be decrypted? Isn't that like a loophole for hackers to gain control of the NIIMS system as it occurred in the Aadhaar system?
Much obliged, my lady. The encryption process, as I said, NIIMS is an evolving system, and it's meant to have hitches here and there, but proper regulation, not invalidation, is the solution. And I'd like to say that Even if NIIMS has its own irregularities, it is to be upheld because having risks as the appellants or petitioners may claim does not equate to unconstitutionality.
Counsel, I'm interested in knowing something. Are you privy to the principles of data protection?
Yes.
Now, in my view,
Yeah.
according to paragraph 2 of the facts,
Paragraph? Sorry?
2 of the facts, the collection of sensitive data is a clear violation of the principle of data minimization as well as purpose limitation, right?
Yeah.
Now, how do you address this violation, and was it necessary for the government to collect this sensitive data such as biometrics, GPS coordinates, retina scans, fingerprints? This is too much data, don't you think so?
Much obliged, my lady. As I stated when I started, is that the right to privacy is not absolute and it can be limited for a legitimate purpose. And I'd like to lead you, move with me to paragraph 16 of the fact sheet, where it states that the respondents also asserts that the inclusion of DNA and GPS coordinates was intended to enhance accuracy and identity verification. They argue that the High Court's judgment effectively addressed any constitutional concerns by declaring these specific provisions unconstitutional while upholding broader framework for NIIMS. It may be that the collection of retina scans, fingerprints, and GPS coordinates may be a violation of rights, but it is legitimate according to Article 24 of the Constitution.
Counsel,
Yes,
we
ma'am.
cannot have limitation coexisting with violation. What is your submission? Was the right violated or was it limited?
It was limited.
Thank you. So on matters limitation of a right, we are very, very convinced with your argument on legitimacy. Our contention, however, is on matters proportionality. The Siracusa principles on the limitation and derogation of rights, they give certain principles which can be summarized into 3: legitimacy, necessity, and proportionality. We do not fight with you in matters legitimacy and necessity. Our issue is on proportionality. Your co-counsel cited the case of Katiba Institute, and in that case, the court held that the collection of sensitive data, including GPS coordinates, without proper safeguards to the right to privacy. We do not contest that the collection was for a legitimate purpose. Our conundrum in this case is that the government, for this case, the petitioner, the counsel for the petitioner, Counsel Wamalwa, cited that as opposed to the Indian system, you have not given any safeguards. The Data Protection Act was not even in force before you started implementing the Huduma number. We also have loopholes in your current legislative procedures or legislations with regard to data. That is Section 25 of the Data Protection Act, as Counsel Melanie has also stated. You do not have adequate safeguards to implement such a system. Therefore, it is our submission that it is not proportional. What is your answer to that, Counsel?
Much obliged, my lady. It is true that we do not have any legal safeguards, but my lady, the Data Protection Act was enacted after the implementation of NIIMS. My lady, since the Data Protection Act was enacted after, applying it retrospectively is legally unsound and unfair. My lady, I would like to lead you to what my fellow colleagues, the appellants or the petitions have stated, that I would like to submit, the respondents would like to submit that the speculation will be immature or speculative, because, my lady, as much as this implementation of NIIMS has come across, NIIMS is something that is evolving and is also viable for hypothetical. Whatever they are saying is that there are risks that can be witnessed. But my lady, this is speculative and this is speculative because in the Okia Umtata case versus the authorities of 2018, my lady, similarly, what was held is that the challenge was premature, and in the system, it was still developing, and public participation was still ongoing. My lady, similarly, in this case of NIIMS implementation, we would like to submit that the petitioners have not provided concrete evidence of privacy rights violation. My lady, NIIMS instead they rely on hypothetical risks that may come across after the implementation of NIIMS. NIIMS is still evolving, and the government is implementing safeguards to rely on public consent. My lady, I would also want to state that NIIMS, there is the Data Protection Act that came after, but the implementation of NIIMS cannot be equated to be unconstitutional because there were no legal safeguards. We have just a minute. We have the Office of the Data Protection Commissioner, which is an independent body that oversees, that is for oversight, that ensures compliance with privacy rights. We also have technical safeguards, and I would like to lead you to paragraph 23 still of the fact, where it states that the respondents also contend that data collected under NIIMS will be stored in a highly secure center base with multiple layers of encryption and access controls. This does not mean that it can be easily accessed, my lady.
Counsel, I'm not satisfied with the answer that you gave me. There's no way you can come before this court and use an example of a system that really failed, but you're relying a lot on the pros but not the cons. You're saying the risks are speculated. How are they speculated? And that system has worked in another country, India, and we have seen a lot of bad things taking place with the use of the system. Can you kindly address on that? And on the issue of using retinas, let me guide you in the petition number 58 that was before this court, where it was stated that when it comes to retina and DNA, they're not stable until a certain age. How is this, how are you coming before this court and saying that, okay, we need this retina, we need this DNA, whatever, and all those kinds of sort, but at the same time we see that they're not stable? What about the people who are below the age 15, where their retinas and all their biological parts are not stable? How are you going to address that?
Very much obliged, my lady. You have stated the age of 15, but I believe the Huduma number is being taken for the age of majority. And I would also like to submit the collection of retina scans, fingerprints, and GPS locations or coordinates is for the accuracy of the NIIMS implementation. Would like a system where it works in a way that there will be no duplication. It is true that it has failed in the other system, but I want to say again that it is a system that is evolving, and there are meant to be hitches here and there, but the government is implementing safeguards to public concerns.
You keep on stating it's evolving. And why would you come up with a system that is, let's say, technically and infrastructurally, and even if you look at paragraph 23 of the case facts, we see a similarity between the other system implication on the encryption and the layers, and it being centrally based, the database being single and being centered. And you're saying it's evolving. Isn't this a replica of the other system to you?
It is true, my lady, very much obliged. It is evolving, yes, and it is a centralized base. And I would like to lead you again to paragraph 1 of the fact sheet, where it states that the NIIMS implementation was mainly to consolidate the information and not to burden the citizens. My lady, we cannot be moving with a system where we have multiple papers in order to gain government services. And that's why we want the implementation of NIIMS as the respondents for the information to be consolidated in one document, which is the Huduma number.
Counsel, the problem that my co-judge is having with your submission is that the right to privacy is not subject to progressive realization. It ought to be realized immediately. So your submission that it is evolving is immaterial here. It needs to be realized immediately, not progressively. It's not subject to progressive realization.
Very much obliged, my lady. Kindly rephrase your question.
You've submitted that the NIIMS system is evolving and it will be better as we continue. Is that your submission, Council?
Yes.
However, that is the concept of progressive realization of rights, that the government has an obligation to realize, but on a slow process. There are rights that are realized in that manner, and there are rights that ought to be realized immediately. The long a luxury that the government enjoys with regards to the right to privacy. Hence, we struggle to really understand the argument on it is about now, because the right should be realized now. What about the violations that are happening now? The right now.
Much obliged. And my lady, I'd like to lead you again to the case of Okia Umtata. The rights may be violated right now, but I'd still stand firm on my decision that the right to privacy is not absolute. And even if we state that privacy rights have been violated right now, I would like to state that the implementation of NIIMS and our submission legitimately meets the proportionality. And if it meets the proportionality test, but my ladies.
Council, can you kindly define for
and Somali documents necessary for NIIMS registration. Requisite requirements